Your Lordship. Warm greetings. This is the Council presenting on behalf of the petitioners in the case of XYZ versus the Republic of Parlamento. Would Your Lordship appreciate a brief perusal of the facts of the case?
Yes.
Much obliged. Much obliged, Your Lordships. So the Republic of Parlamento is the largest democracy in the world with a large population. It consists of people from different strata of the society, people from different religions and educational and financial backgrounds. Your Lordships, during the pandemic of 2020, digital transactions in the country increased manifold and digital assets have been on the rise in the recent times. Meanwhile, the central government of the country implemented a new tax regime aimed at taxing gains and or income from virtual digital assets at a high rate of 30%. The citizens of the nation were perplexed as to when there is no law legalizing the digital currency, digital assets, NFTs, etc., the decision to tax gains from the same is unreasonable. Thereafter, various citizens filed writ petitions before this Honorable Court challenging the insertion of this new Section 115 BBH of the Income Tax Act. The Honorable Supreme Court thereafter decided to hear the said petitions, and the issues raised are mainly two. First, whether or not the government is justified in taxing digital currency, digital assets, virtual digital assets, and two, whether Section 115 BBH of the Income Tax Act is violative of the Constitution of India, violative of the Constitution of Parliament. Apologies. If Your Lordships are satisfied with the facts, the Council seeks permission to present the issues on behalf of the petitioners.
Yes.
Much obliged, Your Lordships. Your Lordships, the petitioner would like to contend before this Honorable Court that firstly, taxation of virtual digital assets by the government is not justified. And secondly, Section 115 BBH of Income Tax Act is violative of the Constitution of India under Articles 14 and 19(1)(g) of the Constitution of Parlamento. I will be dealing with the first issue while my co-counsel will be dealing with the second issue. With the permission of Your Lordships, the Council would now move on to the first issue at hand.
Sure.
Much obliged, Your Lordships. Your Lordships, before addressing the first issue, the Council would like to bring to the attention of the Court certain advantages and disadvantages posed by trade in virtual digital assets. Cryptocurrency is a form of virtual digital asset which is designed to work as a medium of exchange using cryptography to secure the transaction and to control the creation of assets. Crypto is a collection of binary data which is designed to be anonymous and secure, wherein data is converted into codes. These are decentralized in nature, which means no single entity owns or controls them. Therefore, it creates cheaper and faster money transfers with decentralized systems which do not collapse at a single point in future. Additionally, no involvement of third parties such as bank and monetary institutions make such transfers free from single entity control. Security of such transfers is provided by the various algorithms and techniques such as elliptical curve encryption,
let me just interject here. See, we are not here to discuss the viability of crypto or how crypto is going to help you, right? Or how crypto facilitates better transactions. We are here to, speak about the validity of the said section of the Income Tax Act, right? So can we please focus on that?
Yes, Your Lordship, sure. Your Lordship, the Council was just trying to highlight these so that the issue that we are being presented is justified. And
it's okay, noted.
Yeah, thank you, Your Lordship. So, Your Lordship, the Council, while addressing and focusing on the first issue, would like to assert that the taxation of income accrued from the VDAs at 30% is an unjustified move by the Centre. There are several reasons that the Council would like the Lordships to take note of. Firstly, if we conduct a literal interpretation of the Income Tax Act, we won't find any head that provides for the taxation of cryptocurrencies or VDAs. Section 224 defines income. Section 14 lays out the heads of incomes for which tax shall be computed. Section 45 talks about capital gains taxation. Section 28 clearly defines income which will be charged under the heads of profits and gains of business and profession. However, none of these sections clearly specify virtual digital assets, nor give a cause for us to interpret and infer the taxation of virtual digital assets under any given heads. Further, it is nowhere defined. Virtual digital assets are nowhere defined under the act. And
But
something
that's okay. They are doing so after the insertion of this section. Is there anything? I mean, is there anywhere laid in the law that you can't introduce any new provisions or new definition?
The council would like to explain that, Your Lordship, without defining something, we cannot provide a law which taxes that certain thing. The Income Tax Act has to include under its ambit.
Okay,
And
I understand that. But okay, so what if tomorrow they come out and they would actually, properly define each and every aspect of whatever they are covering under Section 115? Will that be acceptable to you then?
Your Lordship, tomorrow if they come and define VDAs and tell us clearly what are VDAs, then obviously the government has every right to tax with giving specific information. Your Lordship, just to further my case here, in the Commissioner of Income Tax versus BC Srinivas Shetty, the scope of Section 45 of ITA was discussed, and it was clearly stated that all transactions encompassed by any section for that matter, must fall under the governance of its computation provisions. A transaction to which the provisions cannot be applied must be regarded as never intended by that section to be subject to the charge. So this inference comes from the general agreement of the provisions of the Income Tax Act, where under each head, income charging these provisions is accompanied by the provisions for computing the income that is subject to be charged. Therefore, if we take this as inference here, there is no head that can. There are multiple heads under which VDAs can be considered. If we look at the ambit of the Income Tax Act, it can be charged as under Section 45 as capital gains, under profits and gains income coming from profits and gains out of a business, and various such things. But there is no clear definition of VDAs in the first place. There is no clear mention of VDAs and where they will be charged, under what head are they being charged, and how will they be computed. And
Sorry, the case that you relied on is under which forum?
Your Lordship, it's under the Supreme Court.
Okay. Is it have you mentioned it in your compendium?
Yes, Your Lordship. Would you like?
Can you guide me? Yeah.
Can I share the?
No, can you just guide me to the page number? I have it open in front of me.
Your Lordship, in our petitioner's memorial, the case is not mentioned.
Okay. Okay, that's what my question was. Sorry.
Okay.
You can continue.
Sure, Your Lordship. So, Your Lordship, the point is that it is extremely unclear, just basing our proof on the act, whether cryptocurrencies will be taxed as under profits on gains out of business, or assets, or currency, etc. And as I have mentioned about BC Srinivas Shetty case as well, further, Your Lordship, this makes the fact that it is not directly can be inferred from the ITA Act, makes governmental clarity as to the legality of such assets crucial, as to whether it and as to what does it recognize as virtual digital assets or currency as. If that is not known, then how will the taxation be justified? However, in such a scenario, Your Lordship, the petitioners propose that determining legal status of such currencies, followed by developing a systematic regulation system, and thereafter creating a clear taxation structure would help this cause. However, the government has neither accepted virtual digital assets are legal, nor has it brought about action to provide for a regulation system wherein, VDAs are clearly defined. There is a system of clear systematic regulation of the people who are trading in such system. And it also claims, the government claims to prevent the harms that cryptos possess. And it has been, repeatedly said by the government that it is its duty to protect the citizens from the harms posed by crypto. Your Lordships, again, the petitioners would agree that cryptocurrencies pose certain harms, which the government has duty to protect its citizens against.
So don't you think you're contradicting this statement by your argument? The government, by imposing such a steep tax of 30%, don't you think it's introducing a deterrent?
Your Lordship, that's what we're saying. It is introducing an unreasonable deterrent on the citizens.
So what should be a reasonable deterrent according to you?
Your Lordship, only taxing an income without a proper regulatory system is not actually posing a deterrent. It is only putting the citizens who are investing at a disadvantage. Nor are they protecting.
That is exactly a deterrent, no? They are discouraging the citizens of the country from investing, if you think about it.
Our argument is that it is unreasonable to place a 30% tax on such income.
But you also want a deterrent. But you think that 30%
Your Lordship, what we're trying to essentially point out is that the government has a right to post taxes, right?
Okay.
Has a right to post taxes. But in this case, it is unjustified because what it is thinking of as a deterrent is not actually being fruitful in such a way. It is causing more harm than it is doing good.
How so? How is it causing harm?
Your Lordship, firstly, by taxing such a high rate, it is only putting the citizens who are investing at a disadvantage. They are not protected against the volatility of the investments. Essentially, the volatility of the investments is what the harm is. But they're not even being protected against it, nor are they enjoying the income.
I understand that, but I don't see how the government can, protect the citizens from the volatility of it, because there is no, the whole point with the matter of crypto is that there is no central governing agency, like what we have for the stock exchanges in India. Correct? Yes. So I don't see how the government can do anything other than taxing, other than putting a tax on the whatever proceeds of the crypto. I don't see what else they can do because there is no governing body as such.
Your Lordship, however, it is, there are several, it is not about whether the government can tax or not. But however, if we look at it, the government has not even tried to put a tax on it. The government has not even tried to come up with a regulatory system. The moment cryptos were introduced, the moment there was a rise in the cryptos, use of cryptos, digital currency here, the attitude of the government has always been to hastily place a ban, which the RBI, of course, reversed, which the Supreme Court reversed the decision and asked the government not to ban such virtual commodities, which will not be fair. But it is.
Counsel, so sorry to interject. You said that an all-inclusive definition and regulatory system does not exist for digital currency and assets.
Yeah.
But don't you think that digital currency and assets themselves are so fluid and dynamic in nature? It's very difficult to provide for an omnibus definition. And for that matter, the government, if in the interest of the citizens of this country, can wait for some time and can provide and come out with a definition, but probably understand the whole regulatory system for itself first, and then do something about as far regulatory regimen is concerned. Do you think this taxing more or less, of course, acts as a deterrent or may not act as a deterrent, but the amount of transfers, the amount of activity that this country has witnessed yet, don't you think that warrants for taxation?
Your Lordship, taxation has no issue as long as you are clear on why you're taxing and how much you're taxing it. There is no
government is clear. The government is clear as to why it's taxing it. The amount of transactions on the digital assets space has increased multifolds, and the government wants to, of course, take care of the revenue to provide for a comprehensive regulatory system in the country that would, of course, keep a vigil on these transactions. Then, of course, protect the citizens from any harm caused by fraudulent transactions in that space.
Your Lordship, even in our second issue, we have mentioned this, and most of the answers would be provided by my co-counsel as well. But however, just to add on, just to answer your question, it is very much acknowledged that the government might in the future come up with a regulatory system, with a comprehensive system wherein it is trying to do that. But putting a 30% tax uniformly right now, it's not guaranteeing the citizens any futuristic just because there is a probability in the future that it might come up, it is not the citizens, it's not in the citizens' interest to just wait until government finds its own space. It is the government who has to take responsibility of its action, and it is the government who has to come up with a regulatory system as fast as possible. It can't put up a tax until then and say that we will take time. That time is not definite. The government has not given us a clear time frame as to how much it will take to come up with a regulatory system. And
but when you look at blockchain, the technology council, from what I understand, and I understand that I don't fully understand it, and nobody does. It's so fluid, and I have so many techniques for mining data in that matter. Tomorrow, if I come up with a definition, and somehow some innovative measure has taken place some part of the globe, it will not take more than a few seconds for that technology or that innovative measure to come and find a room in India, thereby falling outside the definition that I've provided in my regulatory system. Don't you think taxing 30% would deter people from investing until there is a fixed regulatory system? Why can't people wait before the government provides for a regulatory system? Your second issue, of course, answers that why this is violative of these articles, these fundamental articles of the Constitution that you have mentioned. But how do you recognize that this is not justified? Is it not justified because it's violative of the articles in these the fundamental rights of the Constitution, or is it something else? Is it the rate that is the problem?
Your Lordship, the rate is a part of the problem. The rate, as well as the whole scenario or the specification in which or the whole situation in which the tax was implemented is unjustified. Because
I would like to, Jay, if you have anything to ask, I think we should proceed with the second issue.
Yeah, maybe we can come back to this later.
Sure,
Okay.
Your Lordship. My co-counsel would be taking up the second issue now.
Good afternoon, Your Lordship. This is the co-counsel appearing on behalf of the petitioner. So I would be dealing with the second issue, that is whether Section 115 BBH, that is to be proposed to be inserted into the IT Act, is violative of Constitution or not. Before explaining how this is violating the Constitution, in short term, whatever my co-counsel was trying to say, I would like to reiterate in simple terms, stating that the government has the duty to protect its citizens against certain traits which can affect the public at large. It can create a deterrent. But whatever the taxation policy that is doing, it has to be followed with a procedure established by law. That procedure has to be fair, just, and reasonable. The issue here is that the taxation, the 30% tax rate, is not following the procedure that is established by law. Given the facts of the case, the government has proposed to insert Section 115 BBH. But nowhere in the facts it was mentioned that the government wants to give a definition to what is called as a virtual digital asset. Without defining what is a virtual digital asset, and how can the government impose tax on several kinds of, for example, cryptocurrencies, or there are 10,000 cryptocurrencies that are being invented day by day. What is the basis for the taxation? That is not.
Council, the government has the mandate to amend any law for that matter in this country. That has.
Your Lordship, I would like
Rohan, you are breaking. I mean, your connection is a bit weak, I think.
Carried out. A section has been inserted. This is within the government's mandate. Procedure you just mentioned. Am I audible now?
Sir.
Yeah, there is a bit of a disturbance, Rohan.
Okay, listen, let me check if I am able to reposition myself.
Yeah, I think this is better now.
This is better now?
Yeah.
Okay, fine. So sorry about that. Yeah, Council, I understand what you're saying. I'm just saying that government is within its mandate to insert, amend, omit any section for that matter in any law for that matter. just explain to me why the government is obligated to follow the due procedure, and what is this due procedure? Where does it come from? Why do you say that any insertion, for that matter, should precede the definition of for that for taxation on these digital assets? Why is this necessary for the government to look into before they insert a section like section 115 BBH without defining what a digital asset
Your
is?
Lordship, the power of the government to impose taxes comes from the Constitution. And the basis of the Constitution is the fundamental rights. Article 21 clearly states the word due process of law or established by law. And this comes from a landmark judgment, Maneka Gandhi versus Union of India, where they have stated if the government wants to make any amendment to any act that would affect the fundamental rights, that has to be fair, just, and reasonable with a reasonable justification. And this needs to have an intelligible differential. Now, the issue is that the taxation policy is affecting the fundamental rights, that is Article 14 and Article 19(1)(g). The section 115 BBH is explaining, it is stating that income from transfer of any VDA will be taxed at the rate of 30%. Now, the issue is that the 30% tax rate is irrespective of the level of income, and it is not defining what nature of income it will be taxed upon. Talking about level of income, Republic of Parliamento is a nation that has people coming from different economic strata. A person from lower to upper middle class might use 80 to 90% of their income to just spend on their expenses. And if you are taxing 30% over their income, that would in a way affect, in a way reduce their income and increase their expenses, which would create an imbalance in the economy.
Council, I don't think you're getting this right, to be honest. They don't tax on the income. They would tax on the profits, if
Yes.
I'm not wrong. So
Yes.
I don't see how that is reducing or increasing their expenses, for that matter. That is one. And secondly, you said that this is violative of Article 14. But you just said one sentence later that it is equal across all stratas. So that is exactly the opposite of inequality, if I understand it correctly. So please help me understand how that is happening.
In simple terms, Your Lordship, right, the fundamental right, Article 14 states that similar people should be treated similarly and dissimilar people should be treated dissimilarly. Here, a person who is merely investing as a capital asset might get capital gains, and a person who is seriously trading and getting money as the user, working in it as a profession, that might be considered as a business income. The issue is that the government is not clear of what type of income or what type of gains it is going to tax upon. I don't think
they're clear. They're clear.
Your Lordship, in the given facts of the case, the government is not clear over the stand over what nature of income it is on which it is taxing the 30% rate.
No, across all incomes. It's clear. 30% across all. There is no bifurcation made, right?
But
so,
Your Lordship, the council would like to humbly differ at this point that income from transfer of any VDS, that is what it is stated. In the IT Act, if we see the flow, what is a capital asset and what is a capital gain? What is a business income and how it would be taxed? Computational provisions are given. Now, what are we talking about income from virtual digital assets? Would it come under the ambit of capital gains or under business income? That there is no clarity over what government is trying to state. And when we are saying that it is over all incomes, that is where the issue happens. Imposing 30% tax over a person who is seriously trading and a person who is merely investing would affect the small players to leave the market of virtual digital assets.
How would it not affect the serious players? In fact, it would affect the serious players more because they have much more to lose, right? A casual investor will invest 100 rupees. Okay. Let's say assume a profit of 50 bucks, take a tax of 30% on those 50 bucks and leave. But someone who's actually in it every day, who's a very serious player, he is taking a hit on a very, very regular and a direct basis.
Indeed, your lordship. Indeed, your lordship. However, the
So,
person
so the whole point is, counsel, the whole point that me and my brother judge have been trying to make since the very beginning is, it does not matter. Okay, the level of tax, the fact that it has, it is equal, or what, like you're suggesting, it'll affect the smaller players more, or it'll affect the larger players more. Doesn't matter. It is affecting everyone, and that is the whole point of this insertion. That it is acting as a deterrent in general. Now, obviously, for you, that deterrent may be higher. For me, the deterrent might be lower. That is purely subjective. But from the government side, I don't think they are unjustified. Absolutely not. In fact, I feel that we all can positively see the impact the deterrent is having. People are actually discouraged from it. I myself was keen at one point to invest in cryptos, but now I'm not.
Your lordship, here the council would like to give the example of Japan. Japan is a developed country. It has brought up a legislation to tax the cryptocurrencies.
But like you said, Japan is a developed country. You can't compare.
But
we are a developing economy. Japan is among the top 5 economies of the world.
Your lordship, but Republic of Parlamento is also one of the important nations where it is dealing, where its economy is it is hugely growing. We are seeing a tremendous impact in the economy, growth of economy. The point that the council wants to make here is that Japan has made a legislation policy to tax cryptocurrencies with the intent to curb the negatives of cryptocurrencies. However, the taxation is from 15 to 55% rate, considering the level of income. If the earning capacity, how much is the...
Until the economic needs of that nation would be very different from the economic needs of this country. I don't think we need to comparatively analyze the two states. That would bring in no fruition.
Absolutely.
You can focus on answering why the government should have considered to follow the due process. I'm telling them procedure and why it was not followed, thereby being contravention by being in contravention of Article 14 and 19(1)(g), as you mentioned.
Your lordship, the council, in short, would like to submit to the bench that...
Saying that to me...
Your lordship, you're not audible.
Sir, you're on mute.
Am I audible now?
Yes, sir. Now you are.
Yeah, just explain to me in brief. This is all I need from you.
Yes, indeed, your lordship. The point the council wants to make here is that 30% tax, irrespective of level of income coming from investing or trading, is against the right to equality, because dissimilar people are being treated similarly. If a person who is getting a loss, if a person who is seriously trading gets a loss, and a person who is getting loss just by investing 100 rupees, this would affect the small player very much comparative to the player.
But again, council, how can the government control profit and loss? The same risks are there in the stock market. If a small player is getting a loss,
the council would like
one
to
second, let me just make my point.
Yes.
Even when a small player, the same disparities affect in the stock market as well, right? There are huge players and then there are day-to-day players. How can the government be held responsible if the small player is burning his fingers? Government is not coming and forcing you ki baba, you invest in Bitcoin, or you invest in Solana, or you invest in this, or you invest in whatever crypto is going on. That's not the government's prerogative to do that.
Your lordship, even in stocks as well, the taxation is from it is deferred, sir. Like from 0% for low earners and 15 to 20%. There's a bifurcation made. There's a reasonable classification made by the government. Here, there is no classification made as such. Even in stocks, as you're saying, there can be loss and profits. However, there is certain clarity by the government that if you're earning low, this is what I would invest. If you're earning really good, you're consistent. If you're investing in stocks from 2 to 3 years, this is how I would tax you. If you're a recent player, I would tax you in a different way. But this is taxing irrespective of how many years a person is investing, how much is the person earning out of such trade, and whether that person is seriously investing in that. And your lordship, as I've already stated in the fact sheet, it is unclear whether it will be given under the head of capital gains, long-term or short-term capital gains, or business income, or income from other sources. At least gambling or horse riding have been said. They have not been legalized by the government, but they're being discouraged. They're being taxed at the rate of 40%. However, that has been given an explanation by the government. Now, the issue here is that the government before had an intent to ban it, and it was moved away by the Supreme Court. Now, the government first has the duty to explain what is the virtual digital asset that the government wants to tax. In the fact sheet, it is not clear that the government is giving a definition section of what is a virtual digital asset. Would it include a crypto or a non-fungible token, etc.? And secondly, this is being taxed irrespective of level of income, which is not the case in the case of fiat currency such as gold, or as of stocks also. They are being taxed considering the tax bracket and the income earning coming out of such trade. When this is the policy followed by the government in all the other trades, if we want to create a deterrent as well, that has to be followed in the same procedure that the government has been following, based upon the constitution, the proper procedure. And when there is no clarity, when the government is treating people unequally, who are unequally earning or getting gains at the same rate, and that too at a high rate of 30%, first this will force the small players to stop investing, and in the longer run, it would affect the serious players to move out of it. That is what the government's intention is. But the problem is the short-term people, the small players would be at more loss, and this would affect the economy at large. I mean, as of now, we are moving into a digital era where virtual digital assets would be the backbone of any developing nation. That needs to have a proper regulation, and before that, the government can make a taxation policy, but that needs to have a proper procedure. Finally, concluding, your lordship, the virtual digital assets, the 30% tax is creating a stringent tax policy, which is irrespective of level of income, and without defining the nature of income, and first of all, not even defining what is a virtual digital asset. And this is not the case in any other trade such as stocks or gold or any other thing, etc. Therefore, law cannot be an exception to the state. That is why I would like to humbly submit to the bench to hold this 30% tax rate as it is being violative of the fundamentals of the constitution, to hold it as unconstitutional, and it is pleaded that the bench would direct the government to bring up a regulation system regarding the cryptocurrencies and any other decision as it deems fit. Thank you, Your Honor.
Rohan, if you would permit 2 minutes, I would just like to ask a very pointed question.
Go ahead.
See, counsels, I can still understand your argument about this section 115 BBH not, being classified under any head, like all the other incomes mostly have been done in the income tax act. I understand that. Like, what would you, consider it as? Would it be an income from other sources? What would it be, or income from business profession? I understand that argument. Okay, I completely understand. But I'm still not convinced about how this is violating your fundamental rights. Like, if you could just take 2 minutes and give me clear, concise answers on why you think this is, unjustifiable, unreasonable, constitutionally invalid is your contention. So in order for me to rule against the constitutionality of this section, you need to give me at least 2-3 very solid points, very briefly, very concisely, in order for me to make my decision. And please do not talk about taxability. Okay, you've made your point about that.
Your lordship, any simple terms for a fundamental right to be restricted, that needs to have a reasonable restriction. Here it is creating an unreasonable restriction where it is treating unequal people at the same pace, at the same rate, affecting first Article 19, equal protection of law. If small players are there, they need to be protected in a different way. The different rate has to be given. That is not being done by the government. And second thing, if we are giving this stringent 30% tax rate, what happens is small players or people would be forced to leave the market and not invest in this trade, which is the right to trade, right to carry on trade under Article 19. And even if the government has the right to tax it, it needs to give a reasonable classification, an intelligible differential on which a rational classification has to be given. And this procedure, and as this reasonability is not found, we believe that this is violating the fundamental rights of the Constitution. That's it, Your Lordship.
Okay.
Thank you so much, Counsel.
Thanks.
Jennifer, so sorry we had to exceed on the limit. I think it was pertinent for us to do so.
Yes,
It's okay.
sir,
We
it's up to
can
your discretion.
provide similar extension to the other council as well.
It's according to your discretion, sir.
Sure.
Okay, sir.
Yeah, we are ready for the response.
Good morning. The council seeks permission to address the bench collectively as Your Honor. Is that fine? Thank you, Your Honor. Your Honor, my name is Raghav and I appear on behalf of the respondent, that is the Republic of Parliamento. And first of all, I would like to apologize for the absence of my co-counsel. You know, the last minute medical situation just couldn't be avoided and she couldn't join. I'm really thankful that you took that into consideration. Your Honor, I'll be speaking for 30 minutes and after that, in the 30 minutes, I'll be speaking on both the issues, dividing time as it seems necessary. First, I'll be addressing the issue of whether the government is just in taxing digital assets, and then I'll move on to why Section 115 BBH of the Indian Tax Act is constitutionally valid. So if Your Honor is well versed with the facts, the council seeks permission
Indian
to move
Tax
on
Act?
to the issue. Apologies, Your Honor. Apologies. Republic of Parliamentos Tax Act, Your Honor.
Okay.
If Your Honor is well versed with the facts, the council seeks permission to move on to the issues.
Yes.
Much obliged, Your Honor. Your Honor, the government of Parliamento has again taken a major step to protect the citizens by, taxing these virtual digital assets. This is not the first time the government has tried to take an action in this scenario, right? This is just another step which has changed, obviously, as the situation has changed, even though it's with the orders of the Supreme Court, right? But this is just another step. And the reason why I need to emphasize on this is because this is another step to protect the citizens, which is what the government has been trying to do from the very start, right? The government sees these virtual digital assets, which I'll hereby refer on, as VDAs for simplicity, that these VDAs are a threat to people, especially those who, in today's day and age turn towards different things, to turn a quick profit, because as we know, COVID-19 has had a severe impact on the economy, especially with those who are in the lower strata of the income, right? So it is, for them, it's even more difficult. Along with that, it's also the youngsters who are getting trapped in such policies, as the government would like to emphasize. All right. So the government has not done anything unfair, right? Because the government has not based this taxation on a tangent that is some random, right? Rather, the government has taken a close speculation of the market, which reveals very disturbing facts, Your Honor. I'd like to state some forward. In 2021 alone, Your Honor, the world lost over $680 million in cryptocurrency frauds. And these are just cryptocurrency frauds. After that, we have much more things like NFTs, right? Virtual digital assets can be described in numerous forms. There is no one set definition to it right now in any country whatsoever, right? Because this is an evolving market. So cryptocurrency alone has had $680 million of frauds, right? Another case of India that I would like to, stress upon is that in recent news, right, this year, a Karnataka engineer lost over 1 crore of rupees to a cryptocurrency fraud. 1 crore just gone in a minute, Your Honor, right? Now, the sad reality is that this is not an isolated case. The government, since it has looked so closely, the government knows that this is quite common in everyday news among the common people. And on a more problematic note, it's as Your Honor will be very good to judge that these fraudulent schemes are successful because of the disinformation that is easily spread on social media these days among youngsters and those who need to turn a quick profit, right? So the Supreme Court has held in several decisions has held in several decisions that companies are liable for misleading people to invest in their cryptocurrency platforms, as we have stated in our memorandum. Along with this, no surprise to the government. I would like to further state the case that after the government introduced the 30% tax rate, it was no surprise to the government that again the big influencers of the industry with a big social media presence came out and told everyone that cryptocurrency has been given a legal status now, right? They said that no doubt, there is no doubt in the minds of the people that it is illegal. They clearly stated that it is legal from now on, which is obviously not the case. Because of this, the government has had to come out and again clarify on such situations, because the market had created doubts in those who in the minds of those who invest in this, right? Now, Your Honor, I implore you to think by the mind of
the government has not deemed cryptocurrencies as illegal. I agree, but it has not deemed cryptocurrencies to be legal as well.
Yes, Your Honor.
Just imposing a 30% tax doesn't, I don't think it necessarily says directly about cryptocurrencies being legal or illegal.
Yes, Your Honor. Your Honor, that is exactly the point that I'm trying to convey. As you clearly pointed out, we have not made the cryptocurrency or any virtual digital asset legal in our country, right? But yet the big influencers of the market came out on social media and made clear, bold statements that the government has legalized cryptocurrency right now. If you want,
how does social media affect the government council?
Your Honor, because these people are followed by those who invest in this market. Your Honor, this is not just a case of,
in fact, it becomes the paramount responsibility of the government to come up with proper regulations, to come up with proper clarifications, and not just directly arbitrarily impose whatever slab of tax they want to, right? There has to be a proper due process of law, correct? The due process of law has to be followed. Proper clarifications have to be given. That's how people will understand what is happening, right? You can't just like one fine day impose a tax on all PDAs and think that's okay.
I understand, Your Honor. Your Honor, this is what we are trying to do currently. We need to protect those citizens who are easily misled by this disinformation that is being spread, right? Which is why this is just as an interim course, which is, as I would like to please, something that the petitioners have failed to understand. We are not saying that we will ban cryptocurrencies or that we will make them a completely legal tender. We are not saying any of such things, because this is just an interim course of action. And the government clearly believes that cryptocurrencies are a risky investment. We want to disincentivize people from doing.
So there are other ways. There are other ways to incentivize the public from investing, right? Is taxation the only deterrent?
No, Your Honor, but Your Honor, it is one of the easiest form to implement while we come up with better solutions. Your Honor, we need to come up with more comprehensive.
Easiest or the most convenient. Why is the exchequer being benefited by these transactions? Why should you generate revenue on a curve that you put out to contain misinformation?
Yes, Your Honor,
and to protect the small investors like you suggest. They are the ones who are bearing the maximum brunt of it.
Understandable, Your Honor. Your Honor, I would like to tell that the reason the government has imposed, yes, an after effect is that the government gets the money, sure. But Your Honor, we also have to look at the situation that we have compared this to, situations of gambling or illegal money, right? There also the government has complete right to tax, collect tax in such cases. So it is not completely unjust for the government to claim tax on this, even though, we are doing this to protect the citizens. And Your Honor, taxation is something that can very easily control. Your Honor, taxation is something that will be much simpler for these people to understand, right? The government could come out with campaigns that try to make people aware of this situation and be more careful of it, because fraudulent schemes have not been are not a new thing in the financial sector, right? But that just won't work effectively enough, because this is an exponentially growing market at a very fast rate, right? The government has to take some strict action before it can come up with something that is more comprehensive,
like
an amendment to an act.
You propose, or in fact, you cited that gambling is another, phenomenon where the government taxes whatever incentives one gains out of gambling, but you understand that there is an intelligible differentiator that exists there. Say, not every sort of gambling is gambling. Some of them are game of skill as well, and game of skill are perfectly valid. Some intelligible differentia should exist, followed by the due process laid by law. Only then you can have a system like this in place. Don't you think so?
Uh, I completely understand, Your Honor, but we don't just have the example of gambling, right? We also have the example of betting, where there is no skill required whatsoever. We still are have the complete autonomy to
No,
tax
no,
people
no,
from it.
Counsel. I think you're mistaken. When I take examples of something like Dream 11, these have been held to be game of skill, and you might refer to
Have
them as
been deemed
betting,
legal.
and are deemed legal completely.
Understandable, Your Honor. To this, I would like to argue that such acts, first of all, these were enacted by the states, as you would be very well aware, and these have still not been enacted on a national level, right? The reason these have been deemed legal and they are being taxed in a proper way is because it took time to come up with the amendments and make a proper provision for such activities, which is what we're trying to do in our scenario as well. We just need the government needs time, because cryptocurrency is, first of all, not a small market, right?
Council, we are not liking the justification that you're providing, honestly, because just because the government did not have time to come up with something more extensive and more exhaustive doesn't mean you can get away with a half effort, like just just like a simple countermeasure to whatever is happening without thinking about the bigger picture. That's not how it works, right? You should, I mean, there has to be a proper due diligence of every strata and every scenario and every stakeholder who's going to get affected, correct? So how can we let the government get away with a lack of their own efforts, that they were not able to come up with something comprehensive as required by an economy the size of our country? So just because you didn't have time, we should let you get away with just blanketly putting one taxable provision and getting away with it.
Understandable, Your Honor, but Your Honor, we have to look at the international aspect of this. All right, let's consider other nations that are facing such issues, right? Other nations have not come up with any provisions whatsoever, for the same reason that this market is just simply not understood very well right now. As
Have
the
have the other countries at least taxed crypto?
Your Honor, I would like to state the case of, for example, countries like China, Colombia, Bolivia, which have completely outright banned such cryptocurrencies, which is something the
Not
government
a good
has.
example. Not a good example. Again, China is a dictatorial economy, and we are the largest democracy in the world. So I wouldn't agree with that comparison. Same goes for Bolivia and Colombia, I would say.
Understand.
Counsel, in addition to that, you had previously made an attempt to ban the cryptocurrencies, or in fact the virtual assets. That was overturned by the Supreme Court.
Yes, Your Honor.
Are you trying to, by this insurgent, back channel and bypass the Supreme Court's ruling with the
No,
such
Your Honor.
steep rate? Is that the intention and the object behind such an insertion?
No, Your Honor, I would very respectfully like to disagree with this. I understand, the council understands what this scenario might look like, but the government only has best intentions in mind of protecting the people, because, Your Honor, like I stated,
Government did not have the best intentions. This very institution held it to be illegal and in contravention of the constitution. That's why we overturned the said ban. It was not in the interest of the people. You tell me why the insertion of this taxation slab of a steep rate of 30% is valid and justified.
Okay, Your Honor, to tax these virtual digital assets without any. Okay, Your Honor, I would give you 3 points, very simple points to justify our claims here. First of all, Your Honor, this will help us ensure fairness, all right? Even though virtual digital assets are not a legal tender in this country, right, as some people would like it to be, especially cryptocurrencies, they still are a form of property. And it only makes sense for us to tax it. It gives us the full right since they are a form of property and the government acknowledges that. The second point that we raise here is that cryptocurrency is in nowadays used to evade taxes, by disguising the source of income. So this will also help us catch that tax from being evaded, right? This will help us prevent this sort of tax evasion. And the third
How
major
can you
point
explain this? How will this tax evasion work?
Your Honor, so
And what do you
cryptocurrency,
understand by tax evasion? Please explain that as well.
Your Honor, since cryptocurrency is something that is not regulated by any
No,
financial
forget about
institution.
cryptocurrency. Just explain what do you understand by tax evasion.
Your Honor, in very simple words, tax evasion is simply the taxes that a person is supposed to pay to the government, but fail to do so for their own personal benefit.
Agreed. So how is investing in crypto helping with that?
Your Honor, because these cryptocurrencies, right, since they are not taxed right now, they also have no tie-up with a financial institution and they cannot be recognized as of now. So people can easily invest in such currencies, right? They can invest crores and crores and still not pay any taxes of it while they are holding property. As we're telling you, these cryptocurrencies, non-fungible tokens and other virtual digital assets, they have been very strongly contended as being a piece of property, even though they're in the digital space. So with this, they get to not pay taxes, which as the government believes is something that is not fair, and they have all the
No, if
rights
the
to.
government thinks that it is a piece of property and the government has every right to tax it, why not just recognize it and have a regulatory system in
Exactly.
place?
Your Honor, any amendment to an act takes a long time, which is why the government is
No, the government did
taking.
not take a lot of time inserting this section. I don't understand. What's the time about?
Your Honor, this is just an interim measure, as we have told you. We could even refer to the proposition if that would be necessary, that this is only an interim measure.
The urgency of insertion of this section if you term it as an interim measure. Interim measures are taken on record or are processed because there exists some urgency. What is the urgency?
Your Honor, the urgency is simply that this has led to a huge financial loss for the country, especially among those who are not very well educated in this space, including the youngsters.
So the government can try and educate them. RBI also issues guidelines and cautionary information saying that satak rahe, savdhan rahe. Even RBI, the central bank, of course, this entire system is decentralized. That's the whole idea of it. But even then, you can have a cautionary note put out. Take cautionary measures. Why are you taxing it and benefiting from it without having a regulatory system in place?
Without even legalizing, how can you tax very simple thing? How can you tax something which you yourself are not recognizing as legal?
Your Honor,
so is it you can't have it both ways, no, counsel. You can't go ahead and say that it's not legal. But on the flip side,
I understand,
you
Your
still
Honor,
earn so much from taxing it.
I'm sorry, Honor, you cut out there.
I was saying that you can't have it both ways, counsel. You can't say in one stead that it's not legal, and on the other hand, you still impose tax on it and earn the money.
Your Honor, we would like to refer to some very old cases which have simply established the fact that something does not have to be legal to be taxed. Even illegal money can be taxed, right? The government has complete right over this. So that is our only justification for this.
Are you saying it's an illegal money?
No, Your Honor, but Your Honor, this has been put in a gray area. This has not even been made illegal yet, while it has not been legalized.
But that's been put as a gray area by yourself, counsel. That's the whole point. There was no need for it to be put in a gray area, right? It could have been extremely simple. Even while imposing the tax, you could have probably attached a few clarifications. It's not unheard of. Every amendment has a clarification, has justification. Why was that not done? That's a very simple question. That's what my brother just was trying to ask you.
Understandable, Your Honor. If you would wish, I will clarify this right now. Is that as we have given you two aspects before, is that first is ensures fairness, right? Along with that, it is also helping us catch those people who are trying to evade such taxes, right? The third point, which you will, I hope, appreciate, is that we are trying to level the field here, right? Cryptocurrency is not the first form of investment that we have in our financial systems, right? It is nowadays used as an alternative to the traditional financial systems. For example, everyday trading of company stocks, right? Now, taxing taxing cryptocurrency or other virtual digital assets helps us level the playing field between these systems and ensure that they are treated equally. Based on these 3 points, we strongly believe that taxing of virtual digital assets is in complete fairness and is only for the citizens of the country and their
What
well-being.
council, what the government needs to understand is the leveling of the playing field is not necessary with the different types of investments that you can make. The only level playing field you need to ensure is among the different strata, economic strata of the people. Correct? That is what the government is failing to appreciate in this situation, is what I feel.
I understand, Your Honor. Your Honor, we also have to look at the fact that the government does not have to make.
No, council, because it doesn't make sense, right? Because then we wouldn't have different slabs or different heads for different types of income if the government really wanted to level the playing field, right? There is a reason why income of other sources, income from other sources, income from professional business, capital gain, long-term capital gain, short-term capital gain. There is a reason why all these bifurcations exist in our taxation system. And that is to ensure that it is not a playing field, because there cannot be a playing. So I
I
think
completely understand, Your Honor. Your Honor,
Council,
in
the
simple
idea
terms,
of equity is equality amongst equals, not equality amongst all. How does the government warrant equality amongst equals when it comes to virtual digital assets? Explain this to us in 5 lines.
so I will give you very two simple points, I hope, which will be understandable to all. The first point that comes up, which is very easy, is that I have told you before, the government consider these investments in virtual digital assets to be very risky, right? Because of which we deem that it is similar to gambling, and we do not need the concept of tax brackets here to protect people from lower strata of income or higher strata of income or offset their losses. This is simply not necessary because of the nature of this activity and the way it is traded. The second reason is even simpler. Tax slabs are difficult to implement, Your Honor, especially when the people that are dealing with these tax slabs are at a risk of being misled and are not properly educated on such issues, right? A direct 30% tax is as simple as it can get for the people to understand and follow. This is why we have also introduced, taxing directly at source with 1%, because it just makes the system much more simpler for people to follow.
No, even taxing at 10% would be simply understandable by the rest. How does it make any difference? I don't understand. Why such
Your
a steep
Honor,
30%?
we simply wish to de-incentivize people from investing. Obviously, we cannot stop them. We have seen that the market has reached to a level, the enthusiasm of the population that participate in such activities has reached to a point where we cannot outright ban them from participating in such activities. That is why we're trying our best to de-incentivize them, so that in the meantime, the volume of the trades go down and we can come up with better measures to protect the people of this nation.
So you wish to act as an enabler, and yet you want to de-incentivize investing in the digital virtual assets. How does that help? If you really want to be an enabler, start by enabling by putting out the right information, by taking cautionary measures, having a regulatory system in place, and even everything before everything else, start by defining what the digital virtual asset is.
Understandable, Your Honor. Your Honor, virtual digital assets, simply as I would like to contend, cannot be defined in the current space, because virtual digital assets first started with cryptocurrency, as everyone understands, right? But all of a sudden, during the pandemic, these non-fungible tokens got famous as well, right? Everyone adopted this system.
But
So
all of them are based on blockchain. What's the difficulty there? Any token, any digital asset, any code, any number based on blockchain can be a digital asset if it has some inherent value. That's how I see it.
Your Honor, but any technology could come up later on that is similar to blockchain, but not the same. And then the government would again and again have to come up with revisions.
Just put out a notification saying that so and so would also fall within the meaning of so and so. What is the difficulty?
Your Honor, which is why we believe that currently, as of now, defining virtual digital assets makes it easier for the government to operate on such an industry which is evolving at this pace. We believe that with a more comprehensive amendment of the Taxation Act, we will
Council.
introduce.
Council, just tell me, is the government in existence for ease of governing the country, or is the government in place for the welfare of the people? Because
Your
the,
Honor,
the entire essence that I'm getting from your argument is it is just easier for the government to do that.
Your Honor, it is not just easier for the government to implement a 30% tax rate, right? As we have told you, it is easier for the people to understand as well, because
It's
taxation
easy,
system can get.
like my brother just said, it would be extremely easy for all the investors to understand a 5 to 10% slab. It would have been much easier for their wallets to understand as well.
Understandable, Your Honor, but Your Honor, this would not help the government disincentivize the people from investing in such. The government does not want to promote such trades as of now till it comes up with better
But the
measures.
government still wants to earn a lot of money from it.
Your Honor, that is just a positive side effect that the government gets from this, which it is not the main contention in the minds of the government. The government simply.
Okay, so just reduce the tax, no? You can find other ways to disincentivize crypto. I'm pretty sure.
Understandable, Your Honor, but the government strongly believes.
We would be, see, very honestly, we would be very pleased to strike down this provision. Okay, you have 2 minutes to convince us otherwise, because till now we are not convinced.
Okay,
so just
Your Honor,
whatever you want, basic summation of your main contentions, and hope to God that it convinces us. That's it.
Your Honor, two simple lines, because cryptocurrency is a very debatable, evolving market right now. It is just very important for you to understand and note that the tax treatment of cryptocurrency has and will change over time as the government and other regulatory bodies, not just in the Republic of Parliamento, but other nations as well, develop a clearer understanding of the technology and its potential uses. The harmful effects of this technology that we have seen have only been in like the past couple of years, right? This technology has not even properly existed in the Republic for like a decade, right? So we have to understand this will evolve, right? So therefore, a simple tax rate on such digital assets cannot be constituted as, a violation of the fundamental rights, as the petitioner puts it, or as a way for government to earn income from it. This tax rate, even if the government gets some income for it, let's assume for a minute that the government does, right? This benefits the government. It still disincentivizes the people and protects them from such frauds taking place. In the end, it is the citizens of the nation that are being protected from such a tax enactment.
No, they're not. They are the unequal people are being treated equally, and I see a glaring contravention of fundamental rights there.
Your Honor, are you referring to tax brackets right here in your statement?
Absolutely.
Your Honor, I have given you the two reasons. I'll state them again. Tax brackets make it difficult for the general population to understand such a situation.
Okay, so then let's just abolish tax brackets across all heads, no? Then why only crypto is being treated? Why is VDA being given such special treatment from the government? Let's make all heads extremely easy then. Right now, if I want to compute my tax statement or whatever tax liability I have, it's an extremely difficult and cumbersome task for me. Let's just do one thing. No, let's tax Mukesh Ambani and let's tax any Tom, Dick, Harry the same way.
Understandable, Your Honor. But Your Honor, as your other judge himself said, taxing is based on equity instead of equality, right? We cannot tax on every single aspect, because right now, all right, while this is a supplemental income for a lot of people, right, other sources of income like investments in let's say investments in the stock market, right, those are the sole basis, those are the basis for a person's like sole income, right? This a lot of individuals earn only through that medium. for which we have to give them recognition and put them into different
But
tax
how
brackets.
does that matter to the government?
Because Your
Any
Honor, the
individual can
government
have
there.
any individual can have 500,000 sources of income. How does that matter?
Your Honor, because in that scenario, we need, Your Honor, in that scenario, first of all, the government completely believes those things to be legal, and we do not disincentivize them, right? We wish the population earns more through such investments. We do not
But
want to
there
hinder
is
their
a lot
development.
of taxation on stock market investments also, Council.
Yes, Your Honor, but stock market investments are not as
But
volatile, and they're
I'll tell
not.
you what the problem is. Okay, stock markets are extremely volatile. Okay, let's not go there. But the whole point is you do not term taxing the income from the stock markets or whatever other markets are there as disincentivizing. The whole problem is with this term which is being thrown away very loosely. And we believe that blanket taxing like this arbitrarily is not going to help you. That's the whole crux of the matter.
Understandable, Your Honor. Your Honor, this is something that, as I've told you before, this is something that is not new. The government in every nation around the world has implemented taxation on illegal money, that is on money that is gained through illegal sources as well, right? Which is something that does disincentivize such activities, which is why the government
deem crypto and PDA as illegal.
Your Honor, the government simply cannot do that because of the rising interest in it, which is why with the more
but the
comprehensive.
government indeed tried to do that. It was this very institution that overturned it.
Yes, Your Honor, understandable, Your Honor, but we have to understand that, as I've told you before, this market is like ever evolving. Those situations were much different. We have gotten a much clearer picture of it now. The participation in it has increased. The investment in this industry has increased, and the
All
government.
the more reason for you to provide an exhaustive definition of the regulatory system.
Yes, Your Honor, which is why the government, while taking an interim measure, is very strict on coming up with regulations as soon as possible, which will help enable
The
people.
measure is in contravention of Articles 19, 1G and 14.
Then let's do one thing. No, let's strike this interim measure off. And in the meantime, you take a month's time to come up with a proper exhaustive regulatory system, and you can very well tax again at that point, but at
Your
least
Honor,
provide proper explanations at that point.
Your Honor, but you have to understand that such an action is not advisable and will not really benefit, because this will again confuse people more, right? After we put a 30% tax rate on the virtual digital assets, the leaders of the industry, they just straight up came out and said that it's legal now, right? Virtual digital assets.
But
this will create even more confusion, Your Honor.
The confusion was created by the government because they did not attach any explanatory statements along with it. That's the whole point, Council. That's the whole point. The point is, if the government would have come out with a proper, forget about any exhaustive regulatory system. I'm just talking about from a proper, just a basic notification along with the proposed amendment. No industry leader would have come out and said that, "Ha, chalo, it's illegal," or it's legal, for that matter. So don't you think that again is the fault of the government?
Your Honor, I would very humbly like to disagree with you on this measure, because this is not something that the government has created. The market as it exists right now is full of fraudulent companies making fraudulent claims, and these people have big schemes running on that, like trap investors. As I told you, a man just lost 1 crore of his
but the scope was
income.
given. The scope was given by the government, not to speculate. The speculation wouldn't have happened, no, if the government was very robust in whatever they were trying to roll out. Like, for example, take the example of goods and services tax that was introduced a few years back, I think 2017, right? That was implemented with extreme level of efficiency, and that was a countrywide tax. The entire customs excise duty was scrapped, and a one nation, one tax philosophy was adopted, right? And it was implemented in very good fashion.
Yes, Your Honor, but
why is the same? The government is also the same. Why such
Your
lax
Honor,
approach?
you have to understand and look at the scenario that GST also did not just come within a day, within a month, within a year. It took a long time to prepare because you have to consider people, as you said, of all starters to be important participators in such a scenario, right? You have to put their considerations and their well-beings into interest before you can simply come out with the legislation, which is why the government definitely needs a bit more time to come up with legislation. Your Honor, the government is trying its best to come up with such. There are other countries, as I've told you, that have outright banned it, right? Which is why we believe to be on a better platform by coming up with legislation, even though we have taken an interim measure. And Your Honor, you have, even if it might look like that the government is benefiting from such a measure, which I agree with, you have to understand that this at the end will protect the citizens from such tax fraud by, disincentivizing their investments. Your Honor, since the paucity of time, would it be fine if I just
It's okay, we'll
complete
give you
it?
time. Yeah, it's okay.
And, all right, Your Honor, understand it.
See, the whole point is you answered our question yourself, right? You said that it takes a lot of time, and that is when the GST could have been implemented. So who has stopped you from taking time this time? Who has stopped you? Did you introduce any interim measure before implementing GST? Yes or no?
Your Honor, but in that scenario, measures were already in place, right? While
Like
they were
what?
not as efficient, statewide taxes were already in place, which is what hindered that process, and we came up with GST, right? But in this scenario, no procedure exists beforehand from which we can just scrap it and start up with someone new.
So to have a
Something
procedure
had
in
to be.
place, have a procedure in place, and then introduce the taxation regime.
We would be pleased to strike down the uh, amendment right now. You take as much time as you want, and then you come up with it. You tax again. We don't have a problem with it. Simple. Are you okay with that?
Your Honor, but you have to understand that this will completely upheaval the market once again, because the people simply do not understand this industry well enough to realize, the harm it can do. Again, investments will go up, which is something the government does not want, which the court has to understand will be bad for people, and it will create even more
But
confusion in the
who is the
mind.
government to judge and to, you know, help the people with their investments? Are you guys opening your own fund or something?
Your Honor, we are not telling people what to invest in. We are simply trying to make sure that they do not invest in an industry where the harms can be much, much greater than the benefits
Have to
of the
put out a
people.
notification in the Gazette of India stating that this market is extremely volatile. It is not yet recognized in this country. So meanwhile, please be cautious. Please take a cautionary note, and please be careful while investing. What else
Yes,
do you do?
Your Honor, if you are aware, the government has tried to be very upfront about such measures beforehand, before the court struck down the RBI's ban on such
Government was not
cryptocurrencies.
upfront. Government just put up a blanket ban on the virtual digital assets. That's not being upfront.
No,
That's
Your Honor, but before that, you also have to understand that the RBI put out multiple circulars over numerous years telling people to stop investing in such currencies or such virtual digital assets, since they are fraudulent to like big schemes, right? The RBI had done that multiple times. People did not stop, which is why they had to come up with a more stringent measure of completely banning them, which the government understands is
But people
something
did
the
not
court.
stop on their own accord. No, people understand. Even people are not fools. Even they are not, fond of seeing their hard-earned money going away. So everyone exercises some level of caution. What the government can do is show them that caution, which they have done. They should have done. Simple. And then
I
if the government really thinks that the issue is material enough that it warrants extreme level of persuasion or dissuasion that the people would require, then come up with an exhaustive regulatory framework. Simple.
Your Honor, that is exactly what the government plans to do. That is why we have taken an interim measure, and we humbly submit before you that we strongly believe that it is not unjustified on our behalf, because we have given you multiple reasons as to why, first of all, not going with tax slabs is a better idea for the citizens. Along with that, we have also shown you the dangers that such an industry poses to the citizens of this country.
Okay. You can come to your prep.
All right. Thank you, Your Honor. With this, I humbly pray before you that the arguments we have made and the authorities that we have stated in our case, we implore the Honorable Supreme Court of Parlamento that it may graciously please to adjudge and declare that the government is just in taxing such virtual digital assets which are not legalized as of yet, and that Section 115 PBH of the Tax Act does not violate the Constitution of Parlamento.
Okay, thank you, Kamsa.
I think we can give them a minute each for rebuttals. No,
Sure.
petitioners, you have a minute.
Much obliged, Your Lordship. Your Lordship, the petitioners would like to only say that the respondent, our learned respondent, has given a complete unreasonable justification as to why they are taxing it, only because BDAs are difficult to be defined, while countries, and has also cited countries like China, etc. While countries like UK, US, even the Philippines, if you consider only developing countries, have defined such defined BDAs and have taxed them according to tax slabs, right? So it is completely wrong, unjustified on behalf of the respondents that they are saying that it is difficult to define virtual digital assets. Secondly, Your Lordship, just because some unscrupulous messages have been floated in social media, they cannot put a taxation policy and say that this is countering that scrupulous messages, while stating the legal status of such assets would have outrightly made those scrupulous messages invalid. They could have done that, but the government is just escaping responsibility when it is saying that those unscrupulous messages have forced us into putting such a high tax rate. It is completely unreasonable. Finally, Your Lordship, just one mention that the petitioners would like to make is that the respondent has stated that gambling, they have taxed cryptocurrencies equal to gambling and betting. However, gambling and betting are clearly given under the ITA Act. They're defined and what comes under it. However, BDAs are not defined. BDAs do not have a head under the Income Tax Act, under which they will be clearly taxed under. So with that, the petitioners would like to end the rebuttal.
Okay.
Yeah, the respondent, please go ahead.
Your Honor, I will give you simply 4 rebuttals that will make this case very straightforward and make you understand why the petitioner is so unsound in their argument. First of all, the petitioners have come here and said that no section of ITA has provisions of cryptocurrency, but they have to understand the reason. The reason this exists is because we need more. We have to come up with a more comprehensive amendment, which is why it does not exist currently. So their argument does not make sense. They've also said that Income Tax Act needs to define something to tax it, but we have stated before you that this is simply not the case. We can tax something that is not legal. The chair I'm sitting on right now, the government does not have to come up and say that every chair that is sold can be taxed, right? That is simply not the case. Something does not have to be defined to be taxed. Along with that, the second argument that I come up with, that they said that 30% tax will cause harm to the citizens as they will not be protected against the volatility of the market. But the government fails to understand how this will happen, because let's say the government had put just a 1% tax rate, right? That still somehow would not have protected the citizens from the volatility of the market in any way whatsoever. The third argument that arises is that they have put examples of Japan that has put legislation, and but as we have told you, so have other countries like China, Bolivia, Colombia, in which case China is a much more similar country to Parlamento as a rising economy compared to Japan, which is as Your Honor completely in his just argument said that it's a developed nation and one of the most powerful economies in the world. The fourth problem that arises here is that they have said that US and Philippines have implemented tax laws, but they have to understand that once again, these nations are very different. In the United States, such virtual digital assets are more widely adopted. First of all, they have been going on for a much longer time. And once again, the nation is much more developed compared to Parlamento. And the last comes up is that just 10 more seconds. The petitioners have said that the respondents have referred to gambling and betting equal to VDA, which is not our case. We say that they're similar to virtual digital assets while not the same. That is why while we tax them similarly, we are not taxing them the same way. Thank you, Your Honor.
Okay. Thank you, petitioners and the respondent. So how do we do this?
Before
Jennifer?
we conclude, sir, Manav sir instructed me to say that the judges are requested to give the feedback to each of the speakers.
Right away.
Yes, sir.
Okay. You want to go first, one, or how do you want to do it?
Yeah, fine, I'll go first. First of all, congratulations to both the parties for making as persuasive of a case as possible out of the given set of facts. It is a commendable effort from both the fronts. I'll start with the petitioners first. So you had structured your line of arguments really well. It drew a sort of a mind map for me, and it was very easy for me to follow, right from facts to the issues, and how you were going to divide those issues amongst the two of you, and thereby also right away arguing what it was that you needed to argue. You attempted to define virtual digital assets, even though this country, Parliament, does not recognize it. I understand that you borrowed the definition from somewhere, but try and avoid doing that, because when you are given a task to argue on a proposition, uh, I think it's important to do a SWOT analysis and straight away hit the nail on its head. Say that, boss, this is not justified because reason number one, reason number two, reason number three. That would, make a compelling case for your side, and it'll also save you a lot of time and cross questioning. After that, understand there was some grilling involved, uh, but you argued really well when it comes to how this section is violative of the two articles that you cited. However, I felt that you could have, elaborated a little more on the due process, why it's important to follow it, why it was not followed here, what is differential intelligence, and how do you go about that? So you could have expounded a little on that. That would have make again, I would say it does add to a lot of persuasive value. Apart from that, I think you made a great case for the front, pointing out how government is wrong, and why we would be uh, right to hold this insertion as unconstitutional. So again, of course, we have to mark you basis on the parameters that we have to follow as a judge. But that's all I can tell from what I heard. Right. I wish you, both of you, all the best.
Thank you, sir.
Jay, you can give them your
Yeah.
feedback. Then we can go.
Yeah,
with
yeah. Correct. Yeah. So both, first of all, great job, guys. Both of y'all were really, very good speakers, in the sense that the thought process was very clear. The conceptual clarity was visible. Okay, no matter how much we grilled y'all kept coming back, kept coming back. So that is something that is very, very appreciable in a mood. The facts that were stated were very good, very concise, to the point, not more than 30 seconds. That is exactly what I was looking for. Both of y'all had very good diction and command over the language, very confident. So no complaints with respect to speaking abilities as such. Coming to your arguments, I felt you guys had a more, you guys had more scope for an innovative argument, maybe. And it's always fun to argue unconstitutionality, because that is when you can be more creative. Okay. So I felt that your side you could have offered a bit more. Instead, I think you guys focused a lot on the taxation, where you should have focused more on the constitutionality, because I think that was the crux of the issue at the end of the day. Because ठीक है, मतलब है, they have imposed 30% है, I agree. It's unreasonable, it's unjustifiable. Government also does not have a reason. ठीक है, I agree. But the point is, rather than beating around the bush about how there are different heads and how, you know, it's not clear or this or that, or how VDAs are not defined, probably you could have spent more time and explained us about what is intelligible differentia, why exactly is, you know, it being affected. Maybe you could have given more examples. Okay, and something on the lines of basically more and more about the constitutional validity and invalidity of the said provision. That would have been better. But I think overall, what I really appreciated was that you guys had really good clarity, conceptual clarity about what you guys basically see. Whatever happens when you come in and argue in front of a court, you need to clearly understand what you want. Okay, what do you seek from the court? And that was very clear. So that's good. One feedback I would like to give you is, say the prayer properly. Okay, it was not so from your arguments, it was clear what you all wanted, but the prayer did not, you know, I have always gotten this feedback from my seniors, or whenever I have done a boot, that prayer is absolutely paramount. And how you should approach a moot is to know your prayer first and then do a reverse research. That's the approach that I have always followed. So many people underestimate a good prayer, but trust me, a good prayer is very, very essential. So if you can, you know, probably structure your prayer the way you have structured your arguments, I think you guys would do even better. So I think that was my feedback. Yeah, and when we gave you a couple of minutes to sum up your arguments, the summation was done up very well. So that is something that is very important, because even in practical scenarios, you are not going to have 15 minutes or 30 minutes to provide your case. You're going to have 30 seconds. And a judge would hear hundreds of cases throughout the day and hundreds of applications. So it's up to you what you provide in those 30 seconds. So you guys are on the right track with respect to that as well. So that was, again, very appreciated. So yeah, I think this was it for the petitioners. You want to go for the respondent?
Thank
Thank
you,
you.
sir.
Boss, you maintained your composure well.
Absolutely.
And it was a must to do so. See, arguing on behalf of the government is always going to be difficult. So the best way to challenge something, and this is some you could say a side insight, is to challenge the maintainability. Okay.
Oh.
But that was, of course, I read the clarifications, that was not allowed to do so. So you ultimately have to argue on merits. Now, it comes to arguments. I found that your pleadings were a little unstructured, although you skimmed through the facts, which I appreciated. You could have at least elaborated a few important points, such as increased activity of digital assets in this country, and why was it required to be taxed? Why the government should consider this as a property in the first place?
Okay.
I sort of asked you a couple of questions during the line of argument, but just unfortunately, you couldn't just come back on that. I was waiting for it. Those would be arguments such as stating that the government can tax anything that likes without actually defining it first. I want to know why and how. And those would have formed the crux of your arguments. For instance, the first issue is whether or not the government is justifying taxing currency not legalized. You could have simply put out your cited cases or whatever the research that you'd carried with you. Understand this, there is this anticipation exercise that you need to carry out as a respondent. What can be asked? What all should I anticipate and prepare accordingly? Reverse engineer from there, like my brother just said. It's always going to be reverse engineering. Why you want this case to be dismissed? Because this is justified and because it's not violative. Why it's not, why it justifies, why is it justified is up to you. You have to embark on the journey, carry out the procedure like that. This is how you structure your research as a respondent. So anticipate more. Carry out an anticipatory exercise. Thereby, when it comes to how this section is not violative, I think you fell short there. You could have provided a little more material to us for us to consider. It was very important. In fact, these two issues are so interlinked and intertwined. When you say that this is not violative, to a good extent, it automatically justifies your insertion. Because it is within your prerogative to insert anything you like in the interest of general public. Right.
Okay.
Go ahead.
This is my second moot court ever. I genuinely don't know how much they work, but so the thing
It's
is,
okay.
I was
This
thinking,
is a learning curve. That's why the whole exercise of this feedback is for you to be even better next time.
okay. So my question is,
We are not complaining. Yeah, go ahead.
yeah. Okay, so I'm just saying that I was just kind of unsure, but I understood that if I prove the second case, first one would be proved much better and easily. So I just did not know. Can I start with the second argument first and then move on to the first argument?
Absolutely.
I can.
Nothing stops you from that.
Unless the issue is jurisdiction, you can do it.
Jurisdiction as in maintainability.
Maintainability, jurisdiction.
Yeah. So first you have to go with maintainability and then you move on.
Yeah. Because if the case is not maintainable, how can you argue the other issues?
Okay, fine.
That makes the job of the respondent very easy. You can shoot down the entire line of arguments of the petitioners if you say this is not maintainable in the first place. Why do you even need to hear it or entertain this? Right.
Okay,
you're on mute.
I have one more question. So let's say not this one, some other moot court, right? You argue that it's not maintainable, right? But after that, you still have more arguments to make more issues to resolve. You move on to the second argument. Do you say stuff like, okay, listen, even if it is maintainable, it is wrong?
You can.
That is the assumption.
Yeah,
that is the assumption. So it's fine to say that even if this is the case, I'll still prove this part, right?
The key word is assuming but not accepting.
Okay, assuming but not.
You can easily say alternatively. Even that is okay.
Fine.
So this is fine when you structure your arguments. It's acceptable. You don't need to follow the list of issues which are formulated, which is pre-formulated. A lot of moot courts that you would do, I understand you're very young. You would be required to formulate issues yourself after perusing the facts of the case. Since this was exhaustive in this instance, so don't let that stop you. Determine what within this enlisted issue, whatever you formulate, is as a preliminary issue. Focus on that first. Okay. Preliminary issue for a respondent is of primary importance, I would say. Okay. So
I have one more question. So in my memorandum, the second issue, I went on the tangent of Article 21, right to livelihood, that it is, still not fundamental right? But in their memorandum, they were referring to 14 and 19. So what do I talk about in my arguments? Do I talk about my case 21 Which, or do I
See,
like talk about 14
the
and 19?
that's the beauty of being a respondent, right? You do not have the luxury of rebutting them, correct? So how, let me explain. What happens is the petitioners go, the respondents go, the petitioner rebut, and then the only scope of sir rebutting you have is rebutting what they have said. Okay, you cannot introduce any new rebuttals of your own because they are not going to get the opportunity to rebut it again. Correct?
Okay.
So you should, in fact, make use of your arguments, the time that you get to argue, to indirectly rebut what they have also said, in addition to what you also have to say. So that's actually a very big advantage of being a respondent. That
So
in addition to whatever you have to say, you have to be vigilant and attentive of what they are saying. Obviously, you have seen their memo as well, so you have a basic idea of what they are going to say. So I feel you definitely should rebut their arguments going forward. Like whenever
okay,
you're a
so
respondent, you
in my case, I should like build the argument that 21 livelihood, not
absolutely,
so. And
absolutely.
the
And
petitioners say 14 and 19.
why is it not why is Article 14 not being violated? Why is Article
Okay.
19(1)(g) not being violated?
Hmm.
You can say it would make a very good impact.
Okay, fine.
You definitely should do that.
Yeah, once you would have convinced us, or at least stated something on those lines, we would have never asked you why it's not justified. You could have simply said that, boss, since this is constitutional, hence it's valid. You have no business into looking into these provisions.
And as a respondent, your primary role is to destroy the other party's argument. Right? So that's what you should be looking to do.
Okay, fine. So like I can build my own case, but at the same time, like rebut them. I don't have to wait for the rebuttal.
Yeah, absolutely. Because you need to understand one thing, that in the rebuttals, you are at a disadvantage. Because you are going to have 30 seconds to think about what they are saying and then respond properly. So,
that's from my end. Jay, if you have anything.
Yeah, just very similar feedback from my side as well. So I am a stickler for facts. Okay. And I do not appreciate when someone says, okay, if your lordships are well versed with the facts, I'm going to move on to my arguments, because you need to understand that facts are marked. Okay. Facts and prayer is something that is extremely underrated and underappreciated, and also underestimated by voters. Okay? Even so, let it be the judge's prerogative whether they want facts from you or not. You should at least offer to say some facts. In fact, I would suggest, when you say, if I may move on to the facts, and when the judges are saying, no, please, we know the facts, you should offer that I may, if it may please the court, I would want to, very, very briefly state the facts in 3 lines. Just take 15 seconds and say something, because facts are marked. People don't realize that. So if you are not, what happens is, if you're not saying facts for whatever reason, you would either get average marks for it, or you will get a big fat 0. Right? So that is something which I feel you should definitely, at least in your instance, don't say that, if you are, if the court is well versed with the facts, I would like to move on with this. Don't say that.
Fine.
Just say, if it may please the court, I would like to very briefly state the facts. And if the judges are like कि नहीं यार 8-9 सुन लिया सुबह से, same ही है, नहीं सुनना है वापस, तो भी you should once again say कि just give me 10-15 seconds, I'll just give you 3 or 2 very pertinent facts of the case. And you have to be prepared for all the eventualities, that if you're the first speaker, you have to give all the facts in like a minute or so. If you should also be prepared for the eventuality that the judges will say, please say the facts in 5 lines, please say the facts in 3 lines, in 1 line as well. Right? So this is something which I have always followed. It may seem like I'm being a stickler for it, but trust me, it does matter. I mean, it matters to me.
I have one more question. So can I give like biased facts? Can I like give facts in a case
you should, of course.
You have to.
Right.
No, if you see, I'll tell you. If you were listening to the petitioner's facts, they stated a very high rate of taxation, 30%.
Exactly.
The high rate was never mentioned. I mean, if you should look at literally, they were never mentioned in the fact sheet.
Memorable, yeah.
Yeah, but they made sure that to say that it carries some value with it.
Fine. Okay.
You don't have
You're
to.
not here. You're not here to do a social justice. You're here to win the case, right? So
Yeah.
you should do whatever you feel is going to tip the scales in your favor.
Hmm. Okay, fine.
Yeah.
Well,
So
you
that
draft.
was one. Then I felt that maybe it's because it's your second mood. The way you were saying some things was a bit informal. I'm not saying it's bad, but it would reflect badly on your court etiquettes. Right.
Okay.
For example, saying things like, so and so and so and so, right? That's what we are
Oh,
doing, right? So that's not how you would,
fine.
speak to a judge in a court, right?
Hmm.
So just small things you have to be mindful. You will learn, obviously, this learning curve is extremely steep, and obviously no one is expert in the first instance itself. But court etiquettes do matter a lot, because after a point, the research you get and the way you're presenting it obviously will matter. But what will make you stand out is how you present yourself in front of the court, right? How are you managed? In that sense, you were extremely composed. As Rohan said, you were extremely composed in the sense that we were grilling you a lot. We were trying to bring you back to the same things again and again and again, and you did not lose your calm. That's very well appreciated. And that's how it should be, because that's what we were trying to do. We were, trying to put you off your edge, but you did not lose it. So that was something that was really appreciated. You have great confidence. Well, like Rohan said, if your arguments and your thoughts could have been a bit more structured, then it would have probably been better. I understand that from your side, the scope of argument was not that much, but even with the little material you had, I felt you could have done a bit better in terms of structuring it. Right? And the prayer, the same feedback I gave them. Please state your prayers properly.
Okay.
Please do not. There is a particular way to say a prayer. Do not just say it like that. The prayer has to be something that has to have the most impact.
So you just said verbatim as it is in your memorandum, right?
No. I'm not saying just rote learn it.
Okay.
I'm saying say it with an impact. The way you said it in a very normal conversational voice. It has to have a certain level of impact, because that is essentially whatever you have spoken for the 30 minutes. It comes down and boils down to the prayer, right? So prayer is something which you should, before saying the prayer, just take a deep breath, think about what you have argued, right? And then you say in a very measured way, in the lights of whatever. You don't even need to say all that. You can just say it is humbly prayed before this honorable court, then so and so be granted. Or in your case, uphold the constitutional validity of section 115 BBH and any other order that the court may be pleased.
Okay.
Right? That's it. It has to be extremely simple, but it has to be something that would cause an impact. Yeah, that's it from my side.
Take these two insights as side note. Make sure that your surroundings, while at least you're on video conference, are proper. I mean, I understand that you're just in your studio. Yeah.
I'm in my
just blur
hostel.
it,
That's all.
like I have done. Even my room is in a mess,
Okay,
so
fine.
I just blurred it.
Okay. And secondly, when you draft your memo, make sure that it carries no grammatical errors. Forget grammatical errors, it carries no misspellings.
Mine had.
Yeah, I was reading your memo and it read bug investors.
Yeah, I saw that later on. I saw that last night when I was going through it.
I thought to myself, I think maybe I'm getting too old. Every day they have something new coming in. I don't know what bug influencers are these days.
I'm really sorry for that.
Okay, so make note. I mean, just be very careful with the drafting. If you've drafted it, if you read it, I suggest take another two set of readings again before you send something. It's exhaustive, it's a drag, but you have to do it. It will help you in the long run. Okay, so yeah, that's all.
Thank you.
So the speakers can move to the main room. And judges, you have been given a score sheet, I guess. So you got to fill
Thank
that.
you, sir. Really, thank you for the feedback.
No worries. All the best.
Thank you.
So we submit the score